My name is Julie Anderson, as she introduced me. Thank you so much, Kim. I'm a partner at the law offices of Anderson and Associates. We represent real estate investors exclusively. When people meet me on the street, I often say I'm in the business of keeping real estate investors in business, which is more than a full-time job these days. I have multiple departments at our law firm. We have a transactional department when we're helping investors buy and sell, drafting contracts, cleaning up titles. I have an eviction department, which is probably why many of you have seen me before. I'm averaging about 52 evictions a week. I'm probably the highest volume filer in the city. I am, I hope so, and hope to remain that way. I have a collection department. I'm currently sitting on about 8,892 judgments. So if you ever hear me talking about collection law, I tell you a judgment does not mean money, but we are trying to turn it into money. And then I get caught up in a lot of litigation. Litigation with the city, litigation with the state, some federal government. I'm licensed in the federal bankruptcy courts, the federal district courts, Kansas, Nebraska, and Missouri. And today we're really going to be talking about, I'm going to start with evictions, and then I'm really going to get into some of the political, the social, and the legal trends all over this country and what's happening here. I'll start with a very huge disclaimer. Sometimes people don't love to hear from me as I bring forward political messages. I am just the messenger of some of these movements. I am not endorsing these movements, but I think it's important that you understand what's going on around the country, what's trickling in here in Kansas City. And I'm going to be focusing on 8 trends that we're seeing here. Most of them are pretty progressive. They're much slower in Kansas City than they are coming in from the coast. But I always want to give a disclaimer. I wore something very cheerful. I'm going to try very hard to keep this not terribly political, but again, still inform you of what's going on. And we're going to be talking about 2 Supreme Court decisions, which is really shocking. The Supreme Court does not take up landlord-tenant issues. They've been really silent on almost all landlord-tenant issues until 2017, when they handed down 2 decisions that are considered to be more pro-tenant. And that is now tenants are able to bring forward issues of habitability in our evictions, and they have a right to a jury trial, which we're going to get into the nitty-gritty of what that really means. I'm going to be talking about rental licensing, rental inspections, tenant rights, and how they're increasingly being represented by attorneys. Some of the legislative protections in Kansas City for victims of domestic violence. And then some of the more controversial are the criminal now as a protected class from HUD, and I'll end with comfort animals. Everybody hates comfort animals, so I'm going to do it right at the end, and then we can go have a drink. In front of you, I have 2 pamphlets. One is kind of golden for Missouri, one is blue for Kansas. If you don't have one of each color, I've left extras up there. I have reason to believe, based on the large pile of blue, that some of you only have the yellow one. So we'll get those handed out to you. And I might sit through some of this. So just getting started. There are a number of different laws that are going to impact landlords. There's going to be state law, federal law, municipal law, what we call common law, which means just a bunch of cases that courts have handed down that are that give us precedence, and contract law. And I'm going to be talking a little bit about leases, although today I'm really not, I can talk to you for 2.5 hours about leases. I can talk to you for 2.5 hours about tenant screening. I could probably talk to you for 2.5 hours about evictions, but I'm going to try really hard to kind of move through it. So at the end of Missouri, I'll take questions. At the end of Kansas, I'll take questions, and then we'll get into the politics. Okay, Missouri state law. Missouri is a pretty statutory state, meaning most of our law is coming from case law or statutes, and it's very broad. So these statutes apply to all different types of real estate. Unlike other states where there's laws that just apply to residential or just commercial or just farmland. We interpret things in Missouri very broadly. So Chapter 441, and again, I don't expect you to go home and read this, but If you want to know where I'm finding all of this, I think it's good that you know kind of where I'm drawing from. Chapter 441 is covering expedited evictions, leases, and abandoned property. Chapter 534 is unlawful detainers, and I'm going to get into what this even means here in a minute, and breaches of leases and tenants that hold over, and Chapter 535, which is going to cover our rent possession cases. And when you practice law in Missouri, again, we're just drawing from all sorts of different cases as well as these statutes. State law in Kansas. Kansas, you could actually read all of the landlord-tenant law. There's not a whole lot of it. You could Google the Kansas Residential Landlord-Tenant Act and you could read it. I have read it. If you have insomnia, I highly recommend it. But the one nice thing about Kansas is that everything is in a neat little package on one location. But each kind of real estate law has a different act. I'm going to be talking to you mostly about residential today. If you have questions about commercial, it's kind of a different statute. But the Residential Landlord-Tenant Act does not cover any rooming houses, fraternities, employee relationships, hotels, farms, or any commercial property. Federal laws. Probably the ones that will most likely impact you are the Fair Housing Act, which essentially says that landlords cannot discriminate against tenants based on their race, their color, their religion, their gender, their ethnicity, age, disability, marital status, national origin, or sexual orientation. I'm involved in a lot of HUD cases where you evict a tenant and then they say, well, you did that because I'm Muslim. You did that because I'm African American. You did that because I'm a woman or because I have young children. So this is the kind of body of law that's impacting us. Now kind of a hot topic is immigration law. There are sanctuary cities that are not honoring this. Our current president is seeking to enforce immigration policies against real estate owners and landlords. Essentially the law, the federal law, is that you cannot knowingly aid and abet a foreign alien, and there are penalties for doing so. I'm not seeing any of these cases enforced right now in Kansas City. That doesn't mean they're not being enforced in Kansas City, it just means they're not coming to my desk. The Residential Lead Paint Hazard Reduction Act. This is something that I'd like you to just put in your head. If you are renting homes that were built prior to 1978, you need to be giving a lead-based pamphlet and a disclosure, and it needs to be signed by your tenant. If you do not, and you call me and you're caught, I'm going to tell you to write a check. Don't waste your time on me representing you. You're going to be found liable. And another good thing that you need to know, please get these in your leases and then keep them for 3 years. You know, after the tenant moves out, don't shred your file because then I cannot prove that you gave out the pamphlet and you gave the appropriate disclosures. The Fair Credit Reporting Act, if you're going to screen your tenants based on their credit scores and you take any type of negative action against your tenant, that means you require an extra security deposit, you increase their rent, you want them to have a cosigner, a parent, a grandparent, a friend cosign, you need to give them a disclosure that says, I have made this decision based on your credit score. And please do that. Also, if you don't do that, I'm going to tell you to write a check because there's not a lot. When you violate a federal law, and these are probably the 5 most common violations that I'm seeing, especially on that lead-based paint. I mean, it's just going to be easier than litigating it to write the check, but it's because you're here and you now know about it, maybe we can prevent you from writing those checks. And subsidized housing is becoming a really hot topic, and I'm going to get into some of the political movement around it. But Section 8 of the Housing Act of 1937 provides housing assistance to approximately 4.8 million low-income households around the country. And there's a voucher program. Some of you that accept these vouchers, it allows someone with a voucher to move from house to house. There's also project-based rental programs. There's public housing. HUD provides a number of benefits, as does the VA. And if you're involved in those, obviously you're going to need to know a lot more than the 2.5 minutes that I just spent telling you about it. All right, the political climate around evictions. The truth is that evictions are probably the most physical manifestation of the social issues around accessible and affordable housing. So why are evictions getting such a bad rap? I mean, the truth is it's just one thing that people can see. The news channels can come out and they can see people's personal items sitting on the lawn. They see the wealthy investor, kicking it out on the yard or to the curb. So that's really why the conversation is around evictions. It's because it's something that the media can physically manifest in order to start the conversation about what is affordable housing in our country. Some of the most common misconceptions about evictions that I'm hearing are landlords profit from evictions. I find it to be slightly laughable because most people in this room wait way too long to send an eviction to me, and I'm going to be talking a lot about the timelines, but obviously if you're evicting someone because they are not paying you, I don't see how that would be profitable business, but the argument is that because you're collecting late fees in addition to your rent, that you are essentially profiting. You're making a profit from the eviction. Again, I am sitting on 8,892 judgments right now. We're trying to turn them into money. I don't know how many people are profiting from these evictions, but we're working towards it. Investors target economically fragile tenants and capitalize on this fragility. That's probably the next common misconception that we're hearing throughout the news right now about evictions. I suppose, there's plenty of books out there. And the third is that landlords frequently evict based on no just cause. There are no just cause evictions, meaning you've stayed over the term of your lease. There is a movement throughout the country to try and make these illegal, essentially, where you have to go to a court and you have to prove why you're evicting somebody past the fact that they've stayed over the term of their lease. But I don't think, statistically, what we're filing now are non-payments or bad act evictions. But again, these are the misconceptions. Some of the solutions that I have for you are, one, you need a good lease. Like if you have a clearly written lease that spells out the relationship between the parties, I think you win a lot more in court. I like it when landlords address evictions early in the relationship before you give the tenant the key. If you do not pay me, if you do, in my lease documents I have a whole page of what I call no, 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 no. So if you do any of these no's, you will be evicted. I want you to have a clear policy on evictions. One thing that's really unfortunate is that most of you in this room probably just say, I evict people when I'm done. That's not a policy. I want you to say, I evict people, or I send this to eviction when a tenant, despite their age, marital status, race, nationality, religion, regardless of that, I send them at 20 days, I send them at 1 month, I send them at 45 days, I send them after 2 notices, whatever it is, I would like you to have a policy. And then, great news, follow that policy over and over and over. It's great that you're here tonight because this kind of helps you know the law. So once you know the law, you're going to be much more empowered, hopefully, to follow the law and always send appropriate notices. I'm going to be walking you through where to find these appropriate notices. But there's always somebody in the room who will say to me, like, I want to get around that law. Can you tell me how to get around it? What about this? What if I do that? It's almost easier. Let's just follow it. There's an idea. All right, your kind of yellow brochure, gold. I chose gold for Missouri. We're going to be walking through it. I want to give you just a general overview of what an eviction looks like if you haven't been through it. First of all, there's no such thing as self-help in Missouri. That means you cannot put a boot on their car, you cannot remove the door, you cannot change the locks, you cannot put their stuff out on the curb, you cannot go and scream and cuss at them and get them to move, you can't threaten them, you have to file a lawsuit. Like, no getting around it, that's just the way this state goes. Notices are important. I can fix them. That's like one of the very few good things about Missouri, is that if you mess them up, I can fix them. But there's really no reason after tonight that you would ever mess them up, because I'm going to give them all to you for free. I'm going to let you download them in Word, put your logos on them, fill them in. I give you instructions on how to use them. So I want you to use them correctly. Jurisdiction is going to be in the Associate Circuit Courts. So when we file a lawsuit, it's just a short document full of facts, like this is the landlord, and this is the name of the tenant, and this is the address of the property, and this is how much rent is due, and this is what we're asking for. Service, so essentially we file a lawsuit, we have to get service on the tenants. No, you cannot deliver it. No, I don't believe you if you say you did. Neither will a court. It has to be done by either a sheriff or an authorized private process server. I have a company that I use almost exclusively. I keep them very busy all over the city serving my papers. And in Missouri, they have to either touch those papers to the tenant or give them to somebody who's at least 15 years old that's present at the property. So who either lives there or is found at the property. And we have lots of battles over whether or not somebody was 15, and 15-year-olds don't have IDs, and we'll get into some of those arguments. If for some reason I cannot physically touch those papers to a tenant, we have to post it on the door, and then I cannot get a money judgment. So that's kind of one of, it's a disappointing aspect of Missouri law. Our trials are set at the first available setting. This is one way in which judges kick things down the road because they say, well, we're not available. Unfortunately, there's not a day limit, so I can't say I'm absolutely going to get you a trial next Friday. The court can do what the court wants to do. Once I win at trial, we will have a judgment entry, and that's just something signed by the court saying you're entitled to the relief that you're asking for. And I file what's called a writ of restitution. That writ goes to the sheriff, and that's the order from the judge to the sheriff saying remove that tenant and remove those belongings and place them on the curb. The timeline for this process in Jackson County is about 50 to 85 days. Cass 45 to 60, Clay 45 to 60, Platte 45 to 50, and Buchanan 45 to 50. So what this should really be communicating to you is that it will take me 3 months rent to remove them. Plus you've got to turn it and re-rent it. So how many months rent do you want them to be behind before I take 3 months? And 3 is on the exterior. I mean 2.5 to 3. And then you've got to fix it and re-rent it. So you're probably looking at least 5 months of no rental income. And obviously that's very profitable to you, as the common misconception is. But some of you are waiting way too long. I mean, you're waiting 6, 7, 8, 10 months, sending them to me, going, Julie, this is an emergency. It's an emergency eviction. Well, okay. You could collect rent for 8 months, and it's still going to take me 50 to 85 days. And that's when everything goes right. So if you want to open up these golden brochures, what I've done for you is I've given you the ultimate cheat sheet to evictions. And I've written this so that you can take it with you. This is just a lot of knowledge about what these words mean. Several years ago, before I had the website, and before I put the notices up for free, I was really frustrated with a lot of my clients. I kept saying, like, why are you guys using New York notices in Missouri? Why are you practicing Kansas law in Missouri? Why are you practicing Missouri law in Kansas, even more importantly? And why are you sending all these bizarre notices that you're downloading from the internet and got from a friend? And I just determined you don't have any access to good information. You don't have access to free forms. You were going to national seminars, you were buying form packages that didn't comply with either state. You were trying to use them in both states. And so I just said, okay, fine, I'm done being mad at you. I'm just going to give it to you. Now, if you attend the seminar and you don't use the right notices, then I'm mad at you again. Okay, so the first and most common type of eviction we're going to see is the rent in possession. And I've broken down this for you, like, when will you use this? Well, when somebody doesn't pay you. It's pretty much that simple. All we want is money and possession. What kind of notice do you need to send? It's just a demand. There's no requirement in Missouri that you send a 3-day notice, a 10-day notice, an 11-day notice. Don't send a 30-day notice, please. Because what's happening is you're letting people get 2 months behind, and then you're sending them a 30-day notice. I can't file a lawsuit correctly under the law and not honor the notices you've given your tenants. So when you give them 30 days, you just gave them 30 extra days for free. And that's before I take the 60 to 85 days to get them out. So I recommend just a demand. I like notices. I do want you to send them. I have a sample demand on my website that I like that just says, your rent was due on the 1st, it was late on the 5th, today is the 6th, I'm demanding you pay rent. If you are so inclined and it makes good business sense to send a follow-up demand saying, I sent you a notice on the 5th, I haven't heard from you, it's the 15th, this will be sent out for eviction. But I don't want you to get in your mind in Missouri that you have to give them a certain number of days to pay their rent. The rent is due on the date stated in your lease, and it's late on the date stated in your lease. And I personally believe it's late the day after stated on your lease. Even if you give them that window, that late fees don't apply until the 5th, it's still due on the 1st at midnight, and so on the 2nd, it's late.
How do you send it?
Regular, you can send it regular mail. I usually like it when you guys just drop it off. The best business practice is to communicate with your tenants. Now, there's many reasons why you don't want to. There's a few reasons why I don't want to communicate with your tenants. But you can either mail it or tack it on the door. Stop texting them. I'm going to say that 20 times tonight. Texting is driving me crazy. You need to send written notices. So put it in writing on my website, MO for Missouri, KS for Kansas, LAW for the law.com. Under forms, you can download in Word, put in your name, I don't know, print it on colored paper. You can put your logo on it, and they all comply, and they're clearly labeled.
Which website again?
mokslaw.com. And if you see here sample notices in the column under each type of eviction, it'll give you a link for where to find that. Payment. I often get these questions. Do I have to take money? I just want them gone. They don't pay me on time. The truth is, if they pay in full, yes, you must take it. If they don't pay in full, you may take it. I personally feel like you should take it because I'm not going to have a lot of luck on the other side collecting it, potentially, because they're going to move. If they work at McDonald's, then they're going to work at Taco Bell, then they're going to go to Taco Villa, and then I'm just chasing them all around the place. If they've got really good, steady work, okay. If they owe $1, I can evict them. But in Missouri, they pay you in full. Sometimes, I go to court and I'll have wads of cash when I leave. If they pay you, they stay. So there's no way to really kick them out. If they pay us in full, you get your money and then they're back on the lease like normal. Next kind of eviction, unlawful detainers. So these are evictions based on predominantly bad actors. So lease violations, not the worst actors, by the way, but they've got a dog, they've got a boyfriend, they had a party. Really all we want to do is regain possession because we don't want them as a tenant anymore. This doesn't have anything to do with money. Also, sometimes they're on a month-to-month and we're just kind of done with them. So they no-fault evictions, essentially what they're called around the country. A 10-day written notice is required for lease violations, and it's not a 10-day to cure. It's not like, aha, you have a dog. If you get rid of it in 10 days, you can stay. No, it's a notice that says, I know you have a dog. I'm terminating your tenancy in 10 days. There's a sample notice on my website. I try and be really clear on these forms, like insert here the 10th date, date it here, state the landlord here. You are entitled in a judgment to double the fair market rental value after the date of termination. So these can be, I suppose, profitable evictions. Again, the reason the law is that way is because this has nothing to do with rent. These are damages for them being a bad actor. A month-to-month tenancy, you have to give them one term. One common misconception is that when people are drafting their month-to-month termination notices, they'll say like, I'm done with them, it's the 15th of the month, so I'm terminating you effective the next 15th. So May 15th move out. That's not valid. It has to be an entire term. So if you want to send it on the 15th, we have to go all the way to May 31st. One entire term. So that could save you some real heartache, because oftentimes you'll send it from the 2nd to the 2nd or the 4th to the 4th, and then I say, sorry, since you sent it to me on the 5th, I now have to do a whole 2 more months until I can file this lawsuit. So then you're out an additional 3 months before we even get started. Let me think. Tenants are entitled to jury trials, and we're going to be talking about jury trials on rent possessions back here too. A new law that says tenants can request a jury. These are messy, we hate that law, and we'll be talking about it more and how to get around it. But I do want to let you know that is the source of a significant delay on the rent possession, and it's a significant delay on our unlawful detainers if tenants exercise these rights. The third type of eviction is an immediate eviction. So I want to be honest, immediate does not mean immediate. So this is still going to take me 30 to 40-ish days. These are for really bad actors. So we're talking the presence of illegal drugs in or around the premises, regardless of who's in possession of them. Drugs must be located on the premises or nearby. Acts of violence, and property damage to the premises in excess of 12 months rent. So that does not mean they kicked in your door from a party. That means there's severe risk that the property will blow up. Somebody's smoking around an oxygen tank, somebody's falling asleep, somebody's cooking meth. We could go on and on about some of the most severe actors. No notice is required. I highly recommend that you contact an attorney for these evictions. They do go much faster because we'll get faster court dates. We don't have to send a notice, even though I will send a notice. I like to tell people I'm going to evict them. Maybe they'll move. Maybe there's a warrant out for their arrest. Maybe they don't want to come to court. One really nice thing in Missouri for us is that you can execute on these 24 hours after we take the judgment, which is a big, big difference from the former 2 types of laws. One reason I don't like that law, and I don't really even understand, the legislature really wanted to make these expedited, and we appreciate that. But we're talking about people with guns and drugs, and I'm going to send the sweet little property manager out there to evict them herself. And the police and the sheriff's office, they really are, they're taking up some heat on these, because almost always you have to call the police for backup. And right now, sometimes the police are saying, well, we'll come this time, but we won't come again, because we want you to file the writ to get them out with a sheriff's deputy. We need to be able to plan our schedule. We can't just be responding to 911 in the most violent types of situations. And then the 4th type of lawsuit is just a breach of contract. So these are the types of lawsuits that we're going to use when a tenant moves out and you're trying to recoup your damages or losses. So these are probably skip outs or some type of post-move out damage case. The notice required is just a demand. You can get one on my website. And the difficulty with these breach of contract lawsuits are, after they move out, I have a hard time finding them. So if they're not employed in a steady fashion, or you don't have inside information as to where they went, and oftentimes you don't because, well, we just kicked them out or they've skipped out, we do have some difficulty in getting to judgment on these. Also, if they do show up with money, you do not have to accept a partial payment, but you must accept a full payment. And they can request a jury. I don't think I've had a jury trial on one of these ever, so it's pretty rare. Another little top tip for you that's not in this brochure, but if you want to file one of these lawsuits, you need to send the security deposit letter to the tenant's last known address within 30 days of move out. So if you don't do that, a lot of times you're like, well, I don't know where they are, so I just didn't send it. No, the law presumes that a tenant would be responsible enough to forward their address, and I'm going to need to plead that you sent that letter. So send it to, you're essentially just sending it to yourself if you don't know where they are. So just send yourself some mail. And I had some questions earlier. Regular mail, nothing in Missouri law really requires you to do anything. Nothing I've talked about yet requires you to do certified. So no reason to delay any processes or give tenants any more than they're entitled to under the law. There's creeping movements to give tenants more power and more rights, which is one reason, again, use the right notices for the right kind of cases. Any questions about Missouri evictions? No? Yes?
Are you saying that if they skip and you have their security deposit, you mail it to the apartment address and that's the last address you know?
So the question is, am I saying that you have to mail the security deposit to your own address, to the apartment that's empty? And the answer is yes. The statute provides that you must mail it, you must postmark it within 30 days of move out to the tenant's last known address. So if they did not provide you with a forwarding address, it just needs to be postmarked within 30 days to the unit that they have vacated. They are presumed to have forwarded their mail. Oftentimes they have not. You know, there are times when I march into court when a tenant sues a landlord and we have the unopened piece of mail because the tenant never forwarded it to themselves. But that's evidence when it's gone through the mail and it's postmarked and not opened that we sent it.
So you're just gonna hold the letter unopened, address it?
Yeah, or scan it to your electronic file and move on. Yeah, and sometimes they never even pick up their checks. And if they ever come back, I mean, we'll have it then in your file. Yes?
You said or texting. How do you feel about email?
I mean, okay, first of all, if your lease provides for sending notices via email, if it's gonna be a legal notice, I don't love email and I don't love text. I think it should, you know, it just makes my evidence kind of messy. If you ever have to testify in court, the court wants to see official legal notices. So I really don't love text messages, and I know why you guys do it. It's just I've spent too many nights preparing for trials, reading every text message you've ever had with your tenant, and I'm tired. And I think the court is as well, because I have to put into evidence the whole body of text messages. So they're complaining about a leaky toilet, and you're talking about the toilet, and what we're trying to prove is one thing, and then we've got 200 text messages. And sometimes, I mean, there are many circumstances when it's so informal, like laughy face, emoticon, you look great today, happy birthday. Like, the court doesn't want to see that, and that doesn't help me prove my case. And if anything, it often makes the landlord, even if you do text, I want the legal notices to put into trial. I need a clean legal case. So I can move the case as quickly and as efficiently as possible.
Email is better.
I mean, email and text messages, I don't like either of them. I don't like either of them for legal notices. I mean, if you just want to run your business that way, but, I mean, it is what it is. I prefer that you have something spelled out in your lease as to how you communicate with your tenant officially. Some software program or something. Yes?
What challenges do you see garnishing wages?
What kind of challenges do I have garnishing wages?
Yeah, it's hard to do.
Well, I mean, we're garnishing, it's easy. I call it in a collection seminar, I would say bank accounts and wages are kind of the low-hanging fruit. They're the easiest way for me to collect on a judgment. The challenge we see with tenants is, generally speaking, if someone cannot pay their rent, they do not have steady employment. And if they do not have steady employment, if they're working at lower wages, it's just, the money trickles in so slowly over such a long period of time, or they keep moving jobs.
Maybe tenants do pay rent, so it's not judgment against the tenants, and maybe have a private investigator, find out where she works and deliver the notification. It's kind of an answer.
Yeah, I mean, a lot of times, depending on the value of the judgment, hiring private investigators is an option, but it's not necessarily something we want to do on these lower wage ones. Yes?
Emergency evictions, illegal drug activity, you suspect somebody's dealing,
What's your best evidence you need?
So on the emergency eviction, I want you to call the police. Don't tell me that you had an emergency and expect me to go into court and tell the judge that this is an emergency, but you didn't call 911, or at least the police department. So I want a police report as evidence. So otherwise, if you just suspect something, we would send a 10-day and do an unlawful detainer. So it's not really that fine of a line. I mean, the court wants to see, if I'm gonna call it an emergency, I need the evidence to show an emergency. There are many crimes that I have a hard time proving. Prostitution is one, running an illegal business is another. Like, unless I have proof of prostitution, which I do have some, it's an interesting job, but oftentimes we'll just say running an illegal business, and we'll issue a 10-day notice terminating the lease for a lease violation. Kansas, I want you to forget everything you learned about Missouri. Because I do not want you to practice Missouri law in Kansas. Kansas has their knickers in a bunch. The judges hate Missouri. You'll notice that I have 2 offices. I wear 2 hats. I am a Kansas lawyer when I'm practicing law in Kansas. I am a Missouri attorney when I practice law in Missouri. And it's more important that I'm a Kansas attorney than it is I'm a Missouri attorney. These Kansas judges, they can sniff you out if you are, they can look at a lease in 1 second and know that you are not practicing Kansas law. They can look at any pleading and know. They talk different, they walk different, and the laws are very different. So again, no such thing as self-help in Kansas. Can't do it yourself, gonna have to file a lawsuit. Yes, it's business for lawyers. Notices are jurisdictional. That means you cannot mess up a notice. You must have clean notices. I will not file a lawsuit in the state of Kansas until I have seen your notice. I will also attach your notice after I approve it to the petition, because notices are so important in Kansas. If you ever try, if for some reason you own properties in your own individual name and you want to file your own evictions, you cannot do so if you're an LLC, but you really just use my notices. There you go. Great tip for the day. Again, we file a petition. We have to get service of process. One reason why I can move fast in Kansas, this is one great thing, I can always take a money judgment. So I can get service on anyone who's over 12 at the house, personal service, meaning I touch them with the papers, or tack and mail, meaning I just mail a regular mail copy to them and put a copy on the door. The sheriff does all of this usually for free, which we love, and we like to kind of laugh that Kansas presumes that their 12-year-olds are as smart as Missouri 15-year-olds. Only if you live in Kansas do you think that's funny. Another nice thing that expedites this process is we get a trial within 8 days by statute. So I can always get a money judgment, I can tack and mail, I can move to court very quickly, I will get a trial within 8 days, and the sheriffs just have a lot less to do in Kansas, and they just get out there a lot faster. We enter a journal entry, so a lot of times people will bring over something called a judgment, but they don't like that in Kansas. You have to call it a journal entry. You've got to have notices that look like Kansas notices. There's also a writ that the sheriffs will move pretty quickly on. Timeline we're running in Johnson County, 30 to 40 days. So again, we're going from 30 to 40 days, whereas in Missouri we're at almost 85. Wyandotte, we're moving at a very fast 24 days. Leavenworth, 45, and Douglas, I don't know what's going on over there, 90. Sometimes. It's just depending on the judge, and they do things very differently in Douglas. So if you pull out your blue brochure and open it up, interesting thing about Kansas, every single type of eviction is called a forcible detainer. So they don't call them anything different. Over in Missouri, we call them what they are, a rent in possession. We call them an unlawful detainer. In Kansas, we just call them all the same thing. That doesn't make it vague at all. So the first type of eviction is similar to a rent in possession in that we use this forcible detainer type of action just to recover rent in possession if they do not pay within 3 days. So this is where that notice that we all hear about, the 3-day notice to pay or quit, that means, dear tenant, you have 3 days to pay your rent in total or I'm terminating your tenancy. Why we like this is that if they pay after the 3 days, they don't get to stay. So you can take their money and still kick them out. So, another reason why people like it in Kansas. If you do accept money after the 3-day period, you have to send a reservation of rights letter saying, hey, I'm taking this money, but I'm not going back on my 3-day notice to pay or quit. All these notices can be found on my website for free, along with this explanation on how to use them. Tenants are entitled to jury trials in Kansas, but we are allowed to bifurcate, meaning we can deal with possession at a different time than money. So we're still really moving quickly in Kansas. The second type of lawsuit, and this is where people get a little unhappy with me in Kansas, these are like an unlawful detainer. It's still called a forcible detainer. And these are where we have a bad actor. But we have to give them the right to stop being that way. So we have to give them 14 days to clean up their act, or we'll terminate their tenancy in 30 days. The 1430 is required. If it's a month-to-month, again, you have to give that one-term notice. So neither state can you do something from the 14th to the 14th. You are entitled to 1 1/2 fair market rental value as damages. If they do hold over after this 1430 notice. 1430s become quite a game with bad acting tenants. You're like, please clean up the trash on your balcony. They'll clean it up on the 14th day. Can't evict them. Have to send them another notice. The second notice for the same violation can be just a 30-day. But I have tenants that are just bad actors, and we're sending a 1430, sending a 1430, sending a 1430. So you really need to learn how to play that game of 1430s, because it can be kind of a long haul. And this is how we get out almost everybody, all the bad actors, including murder, including violence, including drugs. So unfortunately, when somebody calls up and says, I have a really bad situation in Kansas, I'm like, well, we have to tell them to stop murdering people. And obviously they're not going to be able to cure this one, so then I won't be able to file the lawsuit until the 31st day. And a lot of landlords are just kind of in awe that that is the law, but that is the law. All these notices, again, can be found for free. The third type of forcible detainer is similar to an emergency. Most likely none of you will ever see this kind of action. I have filed 3 of them in probably the most egregious evictions recognizable, and we've won 2 of the 3. The courts don't like them. The courts have not heard of them. Judge Vokins in Johnson County said, don't bring drugs to me under this statute. Unless it's a kilo of cocaine, I don't want to hear about it. So, I mean, I hate to even teach you about it. If we did do it, you would have to post a bond with the court, and by the time I get the bond set and post the bond, I could have done a different kind of lawsuit. So, again, very rare. And the fourth kind is similar to a breach of contract where they skip out. So I want to see those security deposit letters go out. Under Kansas law, it says within 14 days of determination of damages, but no longer than 30 days. So I'm just going to tell you, just send it out within 30 days. Postmark it, send it regular to their last known address, which sometimes means you're just mailing things to yourself. Please go ahead and waste that stamp. It's worth it. Abandonment. I think it's important that you understand it. We're going to use it relatively conservatively. This is the one and only situation where I don't require you to go and file the lawsuit, serve it, get a judgment, go through the whole process. There's a great statute in Missouri, and if you follow it, one thing I love about the statute is the notice that you need. One, you can find it for free on my website, along with an explanation how to use it under the Forms tab. But the notice is contained in the statute. And the first element is that the landlord has to have reasonable belief that the tenant has vacated. So what does reasonable belief mean? Like, I want you to, I don't know, go over there, knock on the door, post a notice, go in, look around. Like, I need you to know that they're not coming back. Don't just say, I heard they're on vacation, I really want to get them out. No, no, no. I need to have a majority of their belongings gone. They have to have not paid their rent for 30 days. So there are at least 30 days in default. And then we post a statutory notice we send a statutory notice, and we have to do it. We post it on the door, send it regular, and send it certified. A lot of landlords do this wrong, or they don't keep that little green card for the certified mail. And I can't prove that you did it, and you have to do it all 3 ways. So if you don't want to file the lawsuit, you don't want to hire an attorney, and you don't want to go through all those hoops and whistles, you need to send it, post it, regular and certified. And then within 10 days after you post that notice and send it certified and regular, if they don't contact you and don't pay the rent, then we just throw their things out. Again, it's fast, it's cheap. You know, you can do it practically for free. I don't know, $8 and some cents, and it takes you 10 days. So a lot of my clients love the abandonment statute and use it very liberally. If you use it too liberally, you can be sued, and you can be found guilty of conversion, meaning you stole all of the tenant's belongings and just threw it out without the process of law. I don't want you to think it's a bad procedure. I just don't want you to think like, I went to the seminar and I found a way around the law. Well, I mean, this is just a different law. Kansas, again, I can't tell you enough. Lose everything I said about Missouri. Whenever you're in Kansas, you have to follow completely different laws. So in Kansas, we have 2 different kinds of abandonment. The first kind is where the tenant just skips out, and we just want to get the property back and re-rent it. And the second is where we've either evicted them, or they've skipped out and they just left a whole bunch of junk behind. They're in jail, they're in the nursing home, they're in the hospital, we evicted them, and they just leave a bunch of stuff there. So the law provides that the first step is if a tenant has been absent for 30 days. So you really need to be documenting, like, how do you know they've been gone for 30 days? Did the neighbor tell you? Did you notice on one day and document that date? And then 30 days later, they're still not there. They have to be in default of their rent for 10 days, and a substantial portion of the property has to be removed. Again, how do you know? Well, let's post a notice, knock on the door, walk inside, look in the windows. I don't want you to try and just kick people out when the Wheaties are sitting on the table and the TV's still there, and you know, like, they just maybe are in the hospital. A notice is not required in Kansas, but I think that's a dumb law. So I'm going to tell you, let's just still send a notice, because how are you really going to know? So post something, anything, saying contact me, I believe you're gone, before you change those locks. I just think it's good business to send a notice, but I don't want to mislead you that there's something required. I've drafted a notice on my website that I think is a good one, and just pretty much says, you know, contact me if you are still here. And if you're really not sure, I'm just going to have you file an eviction, because in Kansas I can move pretty fast, especially if they're in default. We'll send a 3-day. I can be in Wyandotte, you know, in and out in 24 days, and you have a court order to protect you, rather than just kind of guessing, or I don't know. And abandonment of belongings. A lot of my clients do not like this, but after we go through the eviction and then we get them out and they just leave all their junk there. Unfortunately, in Kansas, I need you to store it for 30 days. I need you to send a copy of a notice 15 days before the 30th day, essentially 15 days before you get rid of it. Publish in a newspaper one time, a little paragraph ad. I have a sample ad on my website, you know, Dear Mickey Mouse, living in Disney World. These are the belongings you've left behind. I'm going to throw them out on this day. And then you need to send it to their last known address, probably yourself. And then you can throw it away, or you can sell it, or you can do anything you want with it. I really don't care. But nobody really wants to do this law. Unfortunately, again, even after we get you a court order, you just can't throw their stuff out in Kansas. So we like it in Missouri, we just throw it to the curb. In Kansas, we gotta save it. Yes?
Julie, can we store it in the unit?
Yeah, you can store it in the unit, you can store it in the garage, you can store it in a U-Haul, you can store it in a storage unit. It kind of depends on how much labor you want to put into it. You know, I have clients who, they have these already, they want to be lease ready in 1 week. They don't want to deal with these lawn chairs in the back, so they'll just put them in some corner in another unit. And here, to my top my top advice. I really like legal notices with certificates of service. Why? Because you're not gonna remember, I don't even remember what I ate for breakfast this morning. You're not gonna remember when I get you on the stand and you need to testify exactly how you served a notice, when you served that notice, what time, how you served the notice. Did you give it to somebody? Did you put it on the door? Did you send it by mail? I'm gonna need you to have great recollection for a significant number of years as to what you did. But if you just get in the habit of using notices with certificates of service that you're signing when you're doing it and retaining a copy for your file, you really don't have to remember. And again, I hate text messages because everybody gets a new cell phone and then they don't have any evidence for me. So every time your iPhone melts down or you drop something on vacation or your kid flushed down the toilet, you just lost my case. So I like electronic files, I like written notices, and I love certificates of service. Like what notice did you serve? How did you serve it? When did you serve it? What time did you serve it? What were you wearing? You know, just anything. I want you to document everything. You don't know what the lawsuit will look like in the future. You don't know how litigious your tenants are going to be in the future. And so I love notes. I love electronic records. I love pictures. You know, pictures are worth more than anything. And I'm not talking about like a video like this. You know, I get motion sick watching some of these things. I like pictures. Show me how big the hole was from far back. Then show me a close-up of the hole. And then get me a receipt or something showing what it cost to repair that hole. Great evidence. Just, you know, putting something on your iPhone, not backing it up, not putting it in the electronic file, it's really difficult for me to win some of these cases. I need you to keep all your records in Kansas for 2 years, in Missouri for 5 years. So what I'm asking you to do is to remember what happened 5 years ago. And then I'm gonna put you on the stand and swear you in front of a court and potentially a jury and ask you questions about 5 years ago. That's what you need to be prepared to do in order to win some of these cases. I can't tell you enough about how, I call it trash versus treasures. Tenants think very highly of their belongings, and oftentimes they have, you know, invaluable heirlooms, diamonds. Yeah, they can't pay their rent. They're on Section 8 housing and they make no income, but they have, you know, 2.5 carats of diamonds, and they are willing to file lawsuits. Sometimes they're willing to find lawyers to file lawsuits against you for an obscene amount of money, and then you don't have any pictures. And I just cannot impart on you enough the importance of understanding that trash versus treasure. And always, if you have a good lease, I recommend you address abandonment in your lease. And I have in my lease, it says, if a tenant abandons any personal property, the landlord may dispose of it as provided by law and is hereby relieved of all liability for doing so. Pretty clear. You can do what you want, and they sign that document, so it's a contract. Tenant defenses. I don't want to keep you here too long. Tenant defenses, probably the one that's most controversial is the issues of habitability. The Supreme Court has handed down a decision that tenants are permitted to raise issues of habitability in cases. We don't love that law, so they can come and just say, you know, the place was a dump, woe is me. They must give, here in Missouri, a counterclaim is required, so the tenant will have to file something with the court to raise those issues. They have to give the landlord reasonable notice and time to repair. And we have now clawed back a little good law for landlords, and that is tenants are required to escrow their rent into court in order to raise these defenses in some courts. Depends on whether or not the judge is willing to enforce that decision. Right now, most judges are. In Kansas, again, we love bifurcation. So if a tenant raises a counterclaim against you, I'm gonna go ahead and get you possession. We'll get that thing rent ready, turn that property, and make sure that you can go forward while we're still litigating the issues of the leaky faucet. When I talk about habitability, I want you to really focus on, it's about issues of life, health, and safety. It's not about one dripping faucet or a crack in the wall. It should be about really pretty serious issues. Some common misconceptions about tenant defense is, if somebody's pregnant, yes, we can still evict them. If they have children, we can still evict them. If they are going to become homeless, we can still evict them. If they're sick, we can still evict them. I hear those a lot. But really what I want to impart with you at the end of this section is that judges really just have a lot of judicial discretion to do what they want. And we are in their courtroom, and that's why I really want you to have great notices and give me clean cases. As we're getting on to just kind of the politics right now of what's happening around the country, some of the statistics, there are about 500,000 people on any given day that are homeless or living in shelters. About 11 million households around the country are spending presumably 50% of their income on rent. Another 9.8 million, 30% of their income on rent. And about half of our nation's renting population is really living under crushing debt. That's just the way that it is. And this is one reason why this kind of political movement is coming about. My opinion is that this did not happen overnight. I am not sitting here like, oh, this just happened this year. I think there are many political reasons why people are living in debt. There are many reasons how this came about. I do think it is relatively new. During our last presidential election, I think affordable housing was pretty much not a part of the national conversation. It is becoming a part of the national conversation as our more progressive party hopes that there will be a different president in office. And my third opinion is that this is a market-driven country. The real estate market is market-driven, and it's going to go up and down. This is not terribly insightful, but that is my opinion. Let's talk about this right to housing movement. I don't want to mislead you. It is a national movement. It's coming in from both coasts, and people, political groups are agitating for what I would call transformative change. The Progressive Party is agitating for immigrants' rights, universal health care, fossil fuel abolishment, a living wage, and the right to human shelter is what they're calling it. This is happening on the local, state, and federal level. I think that at the heart of it, it's about power. They're trying to reallocate the power between landlords and renters. They're trying to offer tenants throughout the country stronger tools using government money in order to rebalance this power. I think the aspirations of the movement are pretty radical. I can almost say that as you read some of the articles that it's almost an alternative reality where they're pushing to make socialized housing or kind of common housing a part of everyday American life. That is the movement, the ultimate goal. The Conservative Party has argued that this kind of social housing has failed. It's a failed socialist movement, that it is kind of a den of inequity. It's architectural blight, that people have done everything they can to kind of claw themselves or escape from this type of housing. And the Progressive Party responds by saying that the Conservative Party is racist. I don't know. That's the best that I've read a lot about it, and that's pretty much how I could really sum it up. But let's talk about what it means for you. There are about 8 things that are happening here in this part of the country. The one is, again, the Supreme Court decision that habitability is going to become now an argument that tenants can make. It's very difficult for me to argue every repair that you've ever made on your units and how timely they were and how they communicated to them to you. And attorney's fees can become stifling if you're in trial and I have to start to argue over every text message you and your tenant have exchanged. Rental licensing and registrations, one of the more controversial, rental inspections, the tenant's rights to be represented by an attorney, some of the legislative protections we're seeing for victims of domestic violence, the criminal as a protected class, the right to a jury trial for tenants, and then comfort animals. I don't want to keep you here all night, but I will at least direct you to where you can find some of these laws. So these are kind of the 7 things that I'm seeing the government begin to do in our area. They are requiring landlords that don't live in the area to appoint a local agent, which should facilitate better communication, but if you don't do it, they will file criminal charges against you. Those of us that are registered as an entity, and there's many reasons why I think you should be, you need to appoint a local agent or registered agent. There are all types of rental licensing laws and requirements to pay a fee, business licensing laws and the requirement to pay a fee. You have to, in some jurisdictions, you need to register each and every unit or home you own and pay a fee. And sometimes you need to register each building that you have, and there's going to be a fee. And what we're hearing more and people are agitating about are the interior and or exterior inspections, which of course are accompanied by a fee. Some of the Missouri municipalities, I think, first of all, I don't need to go through with you each and every jurisdiction in the metro area. You can find those on the website, marei.org/ordinance. It's available to everybody in the community. I don't think you need to have any type of password. And Kim is doing a great job.
Trying.
You're doing a great job of keeping that up to date as different municipalities and jurisdictions are adding new requirements. Probably one that people are a little agitated about is the Independence, Missouri requirement to register your units and undergo both an interior and exterior inspection. And the Kansas City, Missouri passed an ordinance called Healthy Homes. This happened in the last election. Healthy Homes is overseen by the health department. It was kind of, the purpose of it is to empower the health department to respond to tenant complaints. This is becoming and will become a thorn in your side if you have whiny tenants. So it is complaint based. So all landlords are required to register. They are equipped to start locating landlords that have not registered and requiring them to do so. And essentially these fees cannot be passed through to your tenants, and it is prohibiting retaliation. So you can't just evict your tenant because they're paying your honey. Yes?
And it's not just complaint based. The health department director can decide if he wants to do random inspections. So he can decide to do 5% of all the rental units in the city or 95% of the units. And so that's another component that people aren't aware of. It's not simply complaint based.
Yeah.
He has a lot of power.
There's a lot of power, and I'm going to give you my pointers about, they're very sensitive right now to retaliation. I think, and my understanding is right now they're not doing random inspections as they're gearing up. This is a very new law. They are doing complaint based. One, I guess, good news for landlords, this is financed by a fee schedule, and if you get a complaint, it's $20 to register, $20 annually. Then if they come out and they have to re-inspect, it's $150 plus $100 for each additional unit, and I mean that gets really expensive. So if you do have good communication with your tenants, I am recommending, and I'm using a form with a couple of clients right now, if the tenant certifies that you have fixed the issue that they were complaining about, it seems like they're willing not to come back out and re-inspect. I don't know how long that will last. Kansas has more favorable laws to us, but they have more laws. Even though they're more favorable, there are lots of them. These are all the jurisdictions that you can find on the website that require just a variety of registrations, and I don't want you to forget the fees. But Kansas law prohibits, which is wonderful through lobbying, the unified government from adopting licensing laws that require interior inspections without the consent of the tenant. Very favorable to Kansas tenants and landlords. So let's talk about why these regulations are in some way good.
Can I give a caveat there, Julie? The stuff on the MAREI website was from my 2 days of research. There was no place to go to find this information, and I emailed cities, and some of them responded and some of them didn't. So
Yeah.
if one of your cities is not on that list, please call them because I couldn't reach them.
Why these are good? I mean, there is a public interest in having safe housing, and the government does need a way to identify the bad actors. I mean, just by the fact that you're in this room and you're trying to get education and you're reading and you're thinking, makes me think that you're probably not the bad actor they're looking for. And there are some protections in these laws for more vulnerable tenants. Some of the cons are obviously increased government interference, punishes good landlords. I mean, there's just a lot of new hoops for you to keep up on, a lot of new fees, and a lot of times these fees are passed through to tenants. Inspection regulations also, in my opinion, do not necessarily afford tenants the same level of privacy to their homes that we are afforded as homeowners. So there are some really negative side effects for tenants. The truth is that without having a warrant, cities and towns across the country are now snooping on tenants. Do you think when they go in and inspect and there's a bong or there's illegal drugs that they're not going to bring in the police? And so just a very quick caveat about the Fourth Amendment to the United States Constitution is that the people have the right to be secure in their persons, their houses, their papers, and their effects without unreasonable searches and seizures by the government, and that a warrant shall only issue upon probable cause. And so there's just a very gray line, and as you can see, as the government begins to interfere more into the private affairs, not just of real estate investors' lives, but also tenants' lives, there are lawsuits against municipalities, cities, states, and the federal government all over the country right now from I guess what they would call the more conservative party, saying you are interfering on the Fourth Amendment rights of tenants and real estate investors. They're not going over very well, but essentially the government is saying that their overarching need, the public interest in safe housing, is greater than the individual's right to privacy. We will continue to litigate this as long as we are probably all alive. Here's my opinion, okay? 43% of the Kansas City metropolitan area lives in a rental home. So you're in a pretty good business, very popular. There are about 330,000 rental units, and approximately 10% of them are substandard. That's just an estimate. So I'm gonna call it the rule of tens. About 10% is what the city right now is looking for. In reality, if you are on the government's radar because of a code violation, because of a tenant complaint, you're on their list. So what do you do to avoid it? I mean, I would say, I think you should comply. I really do think you should comply with the law. If you're required to register, register. Don't try and hide, don't try and sneak around. Just register, get it in on time, stay off their radar. You really don't want to pick fights with some of these city inspectors. I can't recommend enough, don't fight with them. Also, if you do get a complaint, a quick response is favorable to you. Don't ignore it, don't lose it, don't wait for a warrant. Hiring an attorney is a really good idea. I have negotiated settlements for clients that are in very big trouble. If you plead guilty 16 times and then you call me, please don't do it. Like, perhaps call an attorney after the first violation or the second violation. Also, you can plead these out on the city code side without pleading guilty. Because once you get too many guilties, we're looking at a warrant. So, I don't know what to tell you. If you refuse to comply, like any of these laws can become criminal. There's an administrative or a criminal element to all of them. So trying to not abide by the law can result in criminal charges. And screening is more important than it's ever been. If you put bad acting tenants who destroy their property in your units and then they make complaints, I have to get them out without making it look like retaliation while you're going through a code violation, while you're going through the health department inspection. It just gets really messy. So I'm encouraging people more and more as they're screening tenants to consider going out and looking at their units that they're moving from and just really considering issues of habitability and cleanliness in your screening criteria. And please stop being a jerk, especially in writing. Real estate investors are perceived to be very wealthy, like moguls of wealth. So when we're coming into court, they already don't like you, and they don't like me either. But just please, if you're going to be aggressive, which I understand you're heated, and just don't put it in writing. It hurts me every time. Also, I really want you to address inspections in your lease, especially your Missouri leases. Mine say that the landlord has the right to enter the premises at a reasonable hour with reasonable notice for any business purpose whatsoever. In the case of an emergency, including the loss of life or property damage, the landlord can enter at any time and without notice to the tenant. And if you do not have a really great lease, I do have one. I call it my lease baby. It took me about 9 months to draft, which is why we call it that. It is, I think it's very powerful and very clear. Okay, the tenant's right to be represented by an attorney. So under the Sixth Amendment of the United States Constitution, it says in a criminal prosecution, people have the constitutional right to the assistance of an attorney. You're going to hear this on TV, or the Miranda rights. You have the right to an attorney. If you cannot afford one will be appointed to you. You have the right to remain silent. So this does not apply to civil law, that's what evictions are. But there is an incredibly powerful movement to change that, where tenants, they're calling these quasi-criminal, or they're really trying to stretch this to say that tenants are entitled to an attorney, which means these cases are going to become incredibly contested and expensive. And when I'm talking 60 to 85 now, we're talking 120, 6 months, 10 months, and that's a lot of time to be without income. So right now there is free representation available for tenants through a number of political initiatives. Legal Aid of Western Missouri, the Heartland Center for Jobs and Freedom is now parking outside of the dockets, dispensing free legal advice to any tenant, and they have a number of pamphlets and PR initiatives, kind of anti-landlord movements. I am tolerating it. Some days better than others. Also, judges are moving towards mandatory mediation. So if you are filing your own evictions outside of the assistance of an attorney, you may be required to go to court-ordered mediation. I am currently instructing mediators, and I am working with the courts, and you could say why. I even considered not doing it. But I think that the investors need a seat at the table. They need to hear both sides of these arguments. It's not just poor tenants, it's also landlords that need to move on with their businesses. And so I am working with the courts, and we're training judges and former judges, retired judges. We're training lawyers to try to be fair and impartial when they are mediating these pro se landlord tenant dockets. Some new legislative protections, a new ordinance in Kansas City, Missouri, protecting victims of domestic violence, sexual violence, and stalking. The old law used to be, I'm sorry, you still need to move. Remember I said if you're sick, you can still be evicted. If you're pregnant, you can still be evicted. If you're this, you can still be evicted. Well, not necessarily. If you are the victim of domestic violence, sexual assault, or stalking, a landlord now in Kansas City, Missouri has to let you out of your lease with no penalty. The tenant does have to do a few things. They either have to get an order of protection and bring that to you, or documentation signed by a medical provider that they are a victim. So also they're putting new penalties against landlords that retaliate against tenants, saying that if a tenant complains to the health department under Healthy Homes, or if they complain to their landlord about the condition of the property, or they become a member of a tenant union, that you cannot retaliate and evict them for that purpose. So we'll have to establish a different purpose. The criminal as a protected class. This is somewhat controversial. Criminals are not yet. Oh, I did it.
You picked the table.
Oh, I'm sorry. Yes. All right.
Are we even in the
Well,
right spot?
we'll get there. I'll keep going. So, HUD in 2016, which is when I kind of feel like 2016 was kind of the beginning of the trickling of government involvement in the landlord-tenant relationship, or at least I would say an increase in government involvement in this part of the country. And so over the last 2 years is where we've been seeing the majority of what we would call progressive policies starting to hit the Midwest. HUD came out with what they are calling a guidance letter. So I used to tell you when it comes to screening that, all right, I used to tell you, you know what? You do not have to take criminals. You can just say no. You can have a policy that says, I don't want any criminals. That's the old law. The new law is not that. So the Fair Housing Act prohibits intentional discrimination. So where we would see this is where you are letting some people get away with being criminals. You're accepting some applicants. For example, like, oh, I feel really bad for that mother. Yes, I mean, she used to do drugs, but she cleaned up her act. But you know what, I don't feel bad for that African-American young man. Okay, intentional, that shows intentional discrimination, where you have a policy and you have not applied it equally to everyone based on their race, their national origin, their sex, their family status. So that's one reason. Most of the time where you're caught is when people will just call and say, hi, I'm a criminal, can I fill out an applicant? And then somebody who answers the phone says, no, we don't take criminals. Okay, so you really need to be training the people who are taking the phone calls for you if it's not you. If not, I mean, I really recommend we have a fair housing seminar where I can talk at length about it. But also, more controversial, Fair Housing Act also prohibits housing practices that have an unjustified discriminatory effect. What does this mean? If you're using criminal histories to reject applicants, it has been statistically shown that your policies have a disparate impact on African Americans and Hispanic applicants. Why? Well, because in the United States, Hispanics and African Americans are disproportionately arrested and incarcerated. So you just cannot have these blanket policies anymore. I don't know how to be more clear. You've got to have some sort of written policy that makes more sense under the Fair Housing Act. Unfortunately for real estate investors, the burden is on you to show that your policies are necessary to achieve a substantial, legitimate, and non-discriminatory interest. Of course, we have those. Resident safety, right? We don't want to fill up our homes with criminals, and protection of your property. We don't want people who destroy property. So those are our legitimate, non-discriminatory reasons why we have these policies. Unfortunately, if a fair housing lawsuit is filed against you or some sort of complaint, what I have to do is I have to go in and I have to show by reliable evidence that your policy achieved your goal, your legitimate non-discriminatory goal. And it's really difficult to do if you have too broad of a policy, or worse, if you don't have a policy. So a lot of you in this room don't have a written policy. How do I know that? Because 75% of you who have a HUD complaint, and I say, what is your policy? You say, well, it's this, but then I changed it. I never put it in writing, so I've just been, meeting with people and seeing how it goes. Yes? Yeah, and I'm going to give you, if you don't have one, I'm going to give you one for free. Oh, he was saying, like, is it a good idea to talk about, like, okay, no, not certain types of crimes for 5 years? Yes, we're going to have to do that. Essentially, HUD recommends that you have an individualized assessment of relevant mitigating factors other than those contained in a criminal record. I don't really like that, because that, to me, sounds like you're going to sit down and make decisions on each individual, but your policy needs to take into consideration both the crime and the applicant. So sometimes the specific facts surrounding the conviction, the length of time since the conviction, the age of the applicant when they were convicted, if they were 12 and they're 60 and they have a clean criminal history, HUD is just not taking very kindly to you rejecting them. Also, whether or not they have a good rental history, is there any evidence of rehabilitation, and how many convictions have they had? Here's the best advice I can give you. I just think you should investigate an applicant's credit and their rental history before we get to crimes. So 1, if you really want to keep criminals out, they don't have good rental history and they don't have good credit. And then we don't ever have to touch this law. But if you don't have a policy that says first you do this and then you do that and then you do criminals, I can't prove it. And since the burden is on you in these investigations, which is very strange that the person being sued has the burden to prove their own policies. So myself and a number of attorneys, we sat down. We didn't know what to tell our clients, particularly our clients in the multi-housing arena. You know, they were like, we need to know what HUD will accept. And so we wrote something. We just came up with the nature of the crime. There are crimes that I don't think you should ever allow someone in, and those are crimes, violent crimes, forcible rape, molestation, aggravated sexual battery. People that have those types, I'm okay that you have a blanket policy on certain types of crimes. I then moved down at least 10 years since conviction, sentence, probation, parole, murders, homicides, other kinds of violent acts. I go 5 years for kind of property damage, illegal drug possession, 3 years for kind of prostitution, embezzlement, forgery, kind of crimes of dishonesty, 3 years for misdemeanors that threaten the safety of others, at least 3 years for trespass, and then unfortunately, if it's been expunged or purged or it's a juvenile record, I just don't think you can take into consideration crimes. But let's look at their credit, then let's look at their rental history, and then look at this. But if you do not have a policy on criminals, this is the best advice I can give you. You can download it for free on my website. At least then you'll have something. Or you can say you attended the seminar, and so if you ever do get sued, we'll say you had a policy. But here's my problem. If you have a policy and you don't follow it, and you feel bad for little old ladies, or you feel bad for people that go to your church but not a different church, you're really just walking into a problem. Okay, the tenant's right to a jury. This is a Supreme Court decision, the second Supreme Court decision we've had handed down in Missouri. The Supreme Court has historically not given two whoops about us until last year. They have determined that a tenant is entitled to a jury trial on a rent possession case. Why is this bad? Because I can't get you a jury trial in Jackson County for 18 months. So they're going to live in your property for free for 18 months while I'm trying to get to a jury. I'm trying. I have a lot of these. I am winning some on summary judgment. I'm agitating for faster trial settings. The next point is, for me to go to a jury trial, I am estimating costs at somewhere between $7,000 and $10,000. So you just went from a flat $225 to $10,000. That really bites. And it's multiple days, sometimes in trial, jury selection. We as attorneys in this area of law are very unhappy about this law. My best advice, why don't you have a jury trial waiver in your Missouri lease? Mine is so clear. The landlord and tenant hereby waive trial by jury in any action, proceeding, or counterclaim brought by either party, hereto against the other one, or in respect to any matter whatsoever arising out of or in any way connected with the lease, with the relationship of the landlord-tenant, with the tenant's use or occupancy of the premises, or any claim of injury or damage. Everything cannot go to a jury, and I can win if you have that provision in your Missouri lease. And if you do not have it, I can't. You have to go to a jury. So that's, when somebody requests a jury, I am ripping at that lease going, please, please, not 18 months. There are courts that are willing to give us much faster jury trials in 18 months, but we're still sometimes in the third seat, fourth seat, meaning we're revving up to go to trial and then we can't go. We're revving up the next week and we can't go. Let's get off this roller coaster. In Kansas, you cannot have a jury trial waiver in your lease. In many ways, tenants have been entitled to jury trials in Kansas forever, and it's not an issue because, again, I can bifurcate, so I'll get you possession, and we'll deal with the money in the jury trial later. Most likely, we're just going to let it go if they raise that issue. And I think this is an area that we should really push for legislative change. And then finally, that which everyone is angry about. I will end on this note before we can go and have a drink. Mental health is a disability. Fair Housing Act says that you cannot discriminate against people with a disability. What is a disability? It's a mental or physical condition that substantially limits one or more major life functions. So, drug addiction is a disability. Mental health issues is a disability. Sadness is a disability. Depression is a disability. I'm sorry, I know you don't think that these tenants necessarily have these disabilities. It's not your call. You don't get to decide. An animal is a reasonable accommodation. I just can't impart on you enough. I just need you to start pretending like these are not pets. They are like equivalent to a cane or a pair of glasses or a wheelchair. And so when landlords are calling me and they're very, very angry about these animals, I say, would you be as angry if they wore glasses? No. Get over it. It's the law in which we have, and it is it's one in which is commonly abused, but it is the law. So there's a two-part test as to whether or not someone gets what we're calling a comfort animal. 1, does the tenant have a disability? 2, does this animal alleviate their disability? Probably, or I can say it does. Do you have the right to deny a comfort animal? Yes and no. Yes, you have a right. Should you do it? Probably not. You can take into consideration all the burdens and the disturbances, but it's pretty much impossible for me to prove that this Rottweiler required you to have a fundamental alteration to your business or place some sort of true undue burden on you. If you can prove that that dog or that animal is disruptive or that animal is violent, specifically that animal, then you have more of an ability to say, no, you cannot have that.
How many pets can we have a substock?
Yeah, we're going to get to how many they can have also. Next bad news, you cannot charge pet rent. You cannot charge a pet deposit. Remember, these are glasses, not pets. So, this is federal law. So this is the Fair Housing Act. So no pet deposits, no pet rent. You just have to put that aside.
Unless they're considered pets.
Unless they are pets. I mean, if it's a normal pet and they're not coming to you saying I'm disabled and I'm asking for the accommodation of a comfort animal or an emotional support animal is what they're probably more commonly called. Breed restrictions are unlawful. So that means you cannot restrict a comfort animal's breed, size, or weight limitations. I mean, you can have horses, essentially. It's just, that's why we're ending on this. And the direct threat exception. So if you can prove that that specific assistance animal, the one that they're asking to bring onto the premises, poses some direct threat. So the Rottweiler poses a direct threat to the safety or to your property. That specific individualized animal, you're never going to have that kind of knowledge. I mean, I hate to just tell you, but I mean, I feel like when I receive these phone calls, I just spend my time saying, no, 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 no. Any type of fear that you have about a specific breed of dog or type of animal or snake or any animal you can imagine is not relevant evidence. Your fears are not going to be considered. And this is probably the one that I hear the most often is threats of insurance cancellation. This is the number one thing. Landlords are like, nope, my insurance policy says that we can't have dangerous breeds. So can't I reject this comfort animal or this accommodation? Unfortunately, we would have to prove that your specific insurance policy, so we'd have to prove with reliable evidence, meaning your insurance company sent you a letter saying we're going to deny your policy because you've permitted this assistance animal or some increase in premiums. So we need some letter from the insurance company saying this is the damage to you in order to reject them. The truth is that insurance companies are now getting sued. So almost every single insurance company is going to have an exception for a reasonable accommodation animal. So you're not going to be able to use this. And essentially every single real estate investor all over the country was saying, nope, insurance is my defense. And so, I mean, HUD has now just said, fine, we'll just sue insurance companies. So they're not going to stand behind you anymore. Okay, yes?
With that meeting that we had
community regulations. Almost every type, she was asking what about breed restrictions on community regulations. Unfortunately, fair housing applies to all the community organizations, as well as to the insurance companies, as well as, all right, we're almost done. This was my warning to shut up. Recommended documentation. So, one thing you can do, a tenant comes to you and says, I need to keep this pet snake because I'm sad. You can require them to provide you with documentation from a physician, a psychiatrist, a social worker, or a mental health professional that has to meet that two-part test. So you need a letter that says this tenant has a disability and this animal or this animal alleviates that disability. So I have a form letter on my website that you can download for free. It's a letter from you to the tenant saying, I need this documentation. Generally speaking, the tenant will bring that documentation to you when they tell you they need the animal. What do I think you should do with that documentation? I think you should verify that it is valid. I mean, you have to do your due diligence before you just let your property become a petting zoo. So let's take the letter. Let's take a look at it. It probably has a letterhead. It should have a therapist license number on it. You can ask your tenant for the therapist license number and you can verify that. When you are verifying these letters, some things that you need to do. Let's be polite. You know, I know that oftentimes it feels like a scam, but no need to get very emotional in these. You should verify the license number. You probably are not going to be able to talk to your tenant's therapist, nor should you want to, about what kind of disability they have. And unfortunately, the message that I'm telling you is teletherapy, you know, the kind of call-in therapy now over the phone, and online therapy where you can pay $9.99 or $99.99 to get a Certipet letter. These have been found to be valid. So these are valid providers of mental health services, which is considered a disability. Now I'm going to get into what you cannot ask your tenant. Yes?
Can you require them to update that like once a year at the renewal of the lease? Or?
Yeah, I mean, yeah, I don't think that would be every annual. Yeah, fine, make them pay $99.99 every year. You know, if you're redoing the lease and you're redoing the process, I don't see any reason why you don't have to recertify that they're still disabled. I think monthly would be an unreasonable demand on a disabled tenant. But really quick, things I don't want you to ever say to your tenants. You are not entitled to know what disability they have. I don't want you to know. Don't get up in their life and stop texting them about it. So don't say to them, do you have a disability? May I see all your medical records or any of your medical records? Have you ever been hospitalized for a mental illness? Hey, how many sessions have you had with your therapist? Anything else? Don't ask them about their symptoms, their diagnosis, their personal lives. Don't ask them how severe their disability is, how long they've been in therapy, how disabled they are. Drug rehab? Let's not chit-chat about that. Any type of medications they're on, like, just don't. Unfortunately, this is just one area in which if they come to you with a letter and you verify the letter that they are disabled and whatever animal they are seeking comfort from is, it's just a reasonable accommodation. And these lawsuits are just coming down against investors over and over and over to the point that I'm just telling people, like, we're just gonna lose this battle right now. Questions I get, does the dog or does the animal need any type of special training? No, not in this arena, and really not under the ADA either. But they don't need training to be a comfort animal. Can the tenant have more than one animal? Yeah, they can have as many animals as letters that they provide to you as to their need. So it can become kind of messy. But they do have to meet that two-part test each and every time with each and every animal. Any type of animal can be a comfort animal. I have great stories, but why I talk about snakes is that they get loose. So, There can be such thing as a comfort snake. Learn that one. Comfort goats. Learn that one. Any type of animal, really. Yes.
Repeat this if they can't hear, but in a multifamily situation, one tenant has a comfort animal, and it may be an aggressive sort or a snake, and it ends up maybe hurting the child, killing a person, another tenant, and the insurance companies aren't covering it because it's a comfort. Who's liable?
Okay, so the question is, what happens when the comfort snake or the comfort animal harms or kills another tenant? First of all, I'm going to hope that you have the best records possible, meaning you've got a solid lease, a great policy on pets, you have great documentation as to your accommodations, the tenant's request, your verification of the request letter, your communication to them that you've followed the law wholly in making the accommodation, and I think that you will be covered by insurance. I think this is a liability, if, I don't know, if somebody, also they should have insurance, but you would be obviously a more likely person to be sued, but I think your insurance will cover you. And I could talk to you for 20 or 30 minutes about the need to have insurance, the need to be registered as an LLC, the need to make sure that you have an umbrella policy, that you have sufficient insurance coverage, not just for these animals, but because of all sorts of liabilities. Yes.
When we're calling up and verifying previous rental history, can we ask about animals?
I think that when you're calling and asking about, when you're calling prior landlords, can you ask about animals? I wouldn't ask, have they ever had a comfort animal? I would, are they disabled? Can I see their medical records? What's wrong with them? I would go something along the lines of, did they leave the premises damaged? Did they have animals that caused damage to the premises? Would you rent to them again? I mean, let's kind of be better about these. Also, if a comfort animal damages the property and causes problems, bites, leaves droppings that aren't cleaned up, I file evictions on comfort animals. I don't have a problem with that. I'm not saying that they can go hog wild, literally a hog wild all over the premises and hurt people or destroy things or cause, if they're uncontrollable barking. Those are disturbances, and I will issue 10 days or 1430s in Kansas or 10 days in Missouri, and I will file an eviction. But we have to show that it's not in retaliation to them having a comfort animal, and a lot of your behavior in engaging in this process of, I need verification that you're disabled, I need verification that your doctor signs off on you needing this hog. So just kind of try the best you can to go in with the best spirit.
Can we deny that, like snake, even though there's some snake?
So she's asking, can you deny certain types of animals? No. If they have a social worker or a medical professional or a CertaPet online or a teletherapist that is willing to sign a letter that says, I can verify this tenant is disabled and the accommodation requested is the presence of a snake, you cannot look at that snake as a snake. You just really have to look at, you have to look at that snake as a wheelchair, or look at that snake as a walking cane. Yes?
Can I require that they go get their special letter from our specialist?
So you're saying, can I require they see my specialist or some sort of specialist that I endorse? No.
Can you require them that they need to have a local specialist if that's your company policy?
So she's asking, can you have a requirement that they see a local medical provider? No.
If it's in your policy.
Well, my problem with you putting that in your policy is that it could be considered an undue burden to a disabled person. I mean, you're not going to require someone who's crippled to have a certain brand of wheelchair. You're not going to require someone who has issues seeing to have a certain brand of sunglasses. So you can't require a certain type of provider. I think on its face, it would be undue.
Of privacy anyway.
Yeah, I think you should probably stay out of it. Yes.
Now, it falls under reasonable accommodation. Correct. Just like me. So like, I have an older 3-story sixplex built in the 1920s. It isn't accessible to a lot of handicapped people because it's old. So just in the extreme thing, if they have a comfort animal, which happens to be a horse, they couldn't live on the third floor.
So she's talking a little bit about she has an older building and it's not handicap accessible, and she's asking questions about what is a reasonable accommodation, you know, for a handicapped person, and if they had a horse, they couldn't live on the third floor. Would we have to build a ramp essentially to get their horse to the third floor? It's possible. It has to be a reasonable accommodation, and so you can engage into that conversation, that dialogue about the administrative burden, the financial responsibilities of the landlord. But the problem is when it comes to an animal, I can't get you any reliable evidence that says this is truly an undue burden to permit an animal on the premises, particularly if you've allowed animals previously or for other tenants that are just called pets. So I think you're just going to have to take. Yes?
Can I recover damage to comfort animal that's done to my property?
Yes. So the question is, can she recover damages that the comfort animal has done to the premises? Absolutely. Again, if this comfort animal is being disruptive, I can still evict the tenant for that comfort animal's behavior as well as recover damages, but you cannot get an extra pet deposit. Again, I don't ever want you to even use the word pet. It's just not a pet. But just like anything, any tenant does damages, I want you to send out that security deposit letter within 30 days, and we can then claim those damages.
If your surrounding tenants have severe allergies to, say, that cat or dog or something like that, can that be a reason? I mean, why do you have to accept something that you know will make your other tenants leave if they have allergies?
So the question is, what if tenants in the building have severe allergies to dander or that particular pet? There's a bevy of case law that talks about chemical use and cleaning and spices and what are accommodations for other tenants. Essentially, you have to provide reasonable accommodations to all tenants. So I don't know if you'd have to have an air filtration system for the tenant with severe allergies. Again, there's a bevy of case law that talks about cleaning supplies where people, landlords would use certain products in the garden and it would impact a tenant with allergies, and whether or not they have to change how they're gardening or change what they're cleaning or change how they're vacuuming. And Fair Housing has come down and said, yes, that you'll have to accommodate both tenants in the same place. So you may end up having to allow somebody out of their lease. Yes?
If the tenants are gonna sign up, the landlord is a wish to do these things. Can we request cleaning of the property after the tenants moved out, so that the landlord can actually get them?
So the question is, can you require cleaning of the premises after the tenant moves out because they had a comfort animal? Well, you should always require cleaning of every unit when the tenant moves out, and if they don't clean it or have the carpets cleaned or whatever reasonable cleaning, less, it's just like anything. And then if they don't clean it or if they ruin the carpets, then you would file a damages lawsuit, just like any tenant under any circumstance with any animal.
Can we minus from the security deposit from that case?
So the question was, can you apply the security deposit to the damages? Yes, just as any other case.
All those bills, when that lease is up, you don't have to redo it.
So she asked, if all else fails, when the lease is over, do we have to renew it? Again, this is kind of where the controversy of the no-fault evictions comes, but right now in the Midwest, if you have a contract that ends on a date specific, this is both Kansas and Missouri, you do not have to renew it. You are leasing something under a contract to a person for 1 year. I would be hesitant If you have a lot of properties and you've never terminated anybody and you're only terminating this one, I mean, it doesn't look amazing, but it doesn't really, as long as you have some non-discriminatory reason that you might have, I guess you want to release that, you want market rent, you want to increase it, you want to do something else with it, I don't have a problem with that. Yeah.
At the risk of ignoring everybody and taking you off this topic.
Yeah.
I have a question about the other stuff.
Yeah, you can ask a question about anything.
How about we have you guys come up and ask questions? We have a lot of people that need to leave because we're at 9. So can we can cut off now, but you can come up and ask Julie questions still. Does that work? Well, let's get